then still can the respondent put a question about the maintainability? The petitioner put this question before. Your Lordship and your Ladyship, the respective counsel from the respondent has mentioned that if he has committed the crime, then why he did not hide the weapon? He did not hide the weapon because he was about to hide. But at that particular moment when Gabriel, he heard some sound and that some incident are taking place there. When Gabriel reached that spot immediately, at that very particular moment, he was confused where to hide and where to not. Otherwise he could hide that. Your Lordship and your Ladyship, they are putting question on the dying declaration that were made by the deceased. The petitioner most humbly submit before this honorable court that there is nowhere mentioned in section 26 that the dying declaration should be made in front of a judicial magistrate. I'll give a practical example, your Lordship and your Ladyship. Today, after completion after going from this honorable court, while returning to my room, if somebody kills me, may God protect me, but if somebody kills me and I am admitted to an ICU, shall the state or the society wait for the judicial magistrate to reach the place if I am about to die after 2 minutes? The question the petitioner is put before this honorable court. And the most common question which is clear before this honorable court, that if Robert has not committed murder, then why they are taking the plea and the defense under section 22 of the Bharat Sanhita 2023? With this, the petitioner rests.
They have stated that why we should not be, why the acquittal that has been given to Robert is not adequate. But let me clearly that it was upon them, the burden of proof was upon them that they have to go through the procedure of section 368 of BNS along with section 169.
Your Lordship, but it is clearly mentioned in section 108, as I have at the respondent, and I have simultaneously have mentioned before this honorable court that section 108 clearly it states that the burden of proof in a criminal matter, the burden of proof lies on the accused who is taking defense, who is taking the plea of defense. Then how can they put the burden of proof in the prosecution? The respondent is not trying to do anything. They are trying to misinterpret the section, the legal provision, and misguiding the court of law.
But Your Honor, the burden of proof lies on the defense only when he is claiming insanity. He has the burden of preponderance of probability. That if the person claiming defense under section 22 of BNS proves that the preponderance of probability exists, then his burden of proof exists there and there. But according to section 368, they have not taken the procedure, they have not conducted any proper medical procedure, then they do not have the post-mortem reports of Ruby stating the causes, and they are stating that section 104 of BNS burden of proof.
Yet she died because of the heart objection.
But no medical examination of the accused was taken, and is
Your Lordship and your Ladyship, the statement made by Ruby, when the doctor confirmed that when Ruby made her statement, she was in a mentally good condition for a few minutes of time. After that, she again went to coma, Your Lordship and your Ladyship. Then how can the High Court of Yaza deny the dying declaration in the instant case?
Section 368 of BNS states about the medical examination of the accused, not of the respondent accused, the person on whom they are blaming about the allegations. They had to take. It was very much aware that he was under the influence of legal insanity. He had a previous history. Still, they have not abided by the procedure. They did not take him through the procedure. They did not make any medical examination. Second, they are stating that the magistrate. It is nowhere mentioned that the recording should be taken by the magistrate. But when the dying declaration was recorded, after the recording of the dying declaration, they had 2 considerable days. On that day, they could have, if they tried, they could have.
Your Lordship and your Ladyship, there was reasonable delay. There was reasonable delay on the part of Ruby. That the
how can the reasonable delay come in such a case, such a serious case? How can they miss such a serious case?
Your Lordship and your Ladyship, the petitioner most humbly submit before this honorable court about the Magneton rule, where it is mentioned Magneton rule, which was decided by 15 judge bench, that the law presume every person to be sane unless it is contrary proof. Your lordship and your ladyship, the respondent is just misguiding this honorable court by revolving around here and there. Can the respondent prove this at that particular time when the incident took place? He was suffering from a mental disorder, or he was legally insane, that he did not understand the consequence of the act, and which was contrary to law, who did not understand that what he was doing was right and wrong.
Yes, Your Honor, we can prove that during the commission of the act, he was under the influence of unsoundness of mind, because the research that we have presented clearly states that when a person of disorder is under the influence of disorder, his manic episode lasts for a period of 1 week. So it is very much normal that when he was concealing the weapon, he was under the
Your
influence
lordship
of
and your ladyship,
insanity.
if it is like that, if the respondent submitted it rest up to 7 months, then the petitioner submitted, why did he only kill his wife? Why did he only kill his wife Ruby and not her daughter? That means what? It is clear before this honorable court that there was mens rea, there was intention on the part of him to kill Ruby.
How could he kill his daughter? Like it is natural that the incident took place within the closed door of the house.
Denying his statement that he has killed his wife, but you are defending yourself by saying that how can he kill his child, not his wife?
How can he kill his wife and not her child if he was legally insane, your lordship, and taking the plea under section 22 of the PNS?
We are stating according
Your
to all
lordship
the
and your
evidences that we have presented to the court clearly proves that Robert was under the influence of unsoundness of mind, and they are arguing on the acquittal that was given to
Your
Mr.
lordship and
Robert.
your ladyship, the respondent has simultaneously failed to prove that at that particular time he was legally insane. They are proving the evidence before the honorable court, which was.
Your argument is the lower court, the Supreme Court has already excluded the accused person on the basis of the insanity. The lower court excluded that he is involved in the incident, in the murder. Sorry. And the lower court is excluded the accused person on the basis of insanity, and you are denying now in this court that he is not involved in the case.
Obviously, Your Honor, how could an insane
Either the lower
person...
court was not applied their mind, high court was right, or
The respondent has not applied their mind, your lordship.
How could a the counsel is pardon?
what we are dealing with. The lower court is convicted the person today, and the high court convicted the person on the basis of the acquittal, on the basis of insanity, on the ground of insanity. And now you are arguing that that person was not involved in the murder.
Yes, because when a person, just in case I have a disorder and I am going through my normal course of day, and suddenly I get the disorder, then how, if I am considered an insane person, how will I know that the situation that are being taken in front of me, when I will get in my normal state of nature, I won't be able to recall it. It is very simple.
Circumstances are immediately against him. Considering the evidence,
Considering the evidence, your ladyship,
object.
but the evidence, the disorder that he was going through lasts from 1 week. It normally lasts for a period of 1 week.
And it was your ladyship, it was diagnosed as per the statement of the respondent before 1 week. But the incident took, as per her statement, the incident took place after 1 week. But the respondent failed to prove that at that particular day he was legally insane, your
But
lordship.
your ladyship, the respondent was diagnosed with the first stage of bipolar disorder from before 9 to 10 months ago, and the incident has taken place after 9 to 10 months has taken place. So the rapid cycling stage has
It's
over.
just the first stage of DMT miscounsel. How can a person on this first stage?
Because the research report itself proves that.
The gravity of an offense.
Because the research report itself proves that when a person is in a rapid cycling state, he can do any extreme level of act, any violent act is expected from him.
Then
I have presented the research articles in front of you.
People should not be acquitted. They should not be left open in the society.
No, Your
You were saying that the High Court has accepted that you are suffering from both medical insanity and
Yes.
right. So have you, presented any evidence now in the court in this regard?
Yes, there is a medical. Yes.
Legal insanity.
Ruby has taken Robert to Mr. Daniel for the checkup, and when we diagnosed her with the first stage of bipolar, we have the prescription.
Your Lordship and Your Ladyship, Ruby took her husband to the doctor many days before the incident that took place. But the respondent has simultaneously failed to prove that at that particular moment, at that particular day, at that particular moment when the incident took place, he was legally insane. Ruby took her husband to the doctor before 1 week or many days before the incident that took place.
Yes, before, because
Now
when
go through your point number 13. Number 13. High Court relying on
yes,
with
the respondent feeling aggrieved by the said judgment, preferred an appeal before the High Court of Yalda on date 20th December 2024. The High Court, relying on the version of the doctor treating the accused for bipolar mood disorder, found that the accused at the time of the committing crime was suffering from both legal and medical insanity, and accordingly the court acquitted the accused from the charges of murder.
So you are admitting that the accused is committing not crime according from the legal information.
We are still saying that he does not know who has committed the act. He was just present in the scene, and therefore he was in his unsoundness of mind. Therefore he is taking the plea of insanity, because the moment
Your Lordship, if he has not killed, then why, if I did not commit a crime, why should I take a defense?
because
You have nowhere mentioned here about your denial regarding the offense, commission of offense.
Have you mentioned
even we did not have mentioned that we are admitting to the offense, Your Lordship.
But it is regarding this only.
Yes, it is regarding, but we are just claiming the defense under section 22. We are nowhere admitting that Robert has admitted. Even the statement of Robert, he did not admit anywhere that he has committed the act, but he stated that during the act, when the act was committed, he was of unsoundness of mind.
That means denial is defense is on the ground of insanity.
Yes. Because he was found on the crime scene. They are presenting evidences, the forensic evidences, which are not reliable. No blood stain was there. Even they are dragging.
How can a blood stain be visible, Your Lordship and Your Ladyship? It was an internal injury. It was an internal
My
injury of the
opponent
body.
counsel is stating that section 368 is not necessary. The blood stain on the forensic report is there. Then what is necessary to prove the accused beyond reasonable doubt?
It was an
We are
internal
proving-
injury. Then how can the blood be transparent in the forensic report, Your Lordship? It was an internal injury. It was an internal injury, Your Lordship and Your Ladyship. Then how can the blood be visible and transparent in the forensic report?
When a person will be hidden with an object, they are considering that the X was you. Then the forensic report will state that there has been blood stains. Only just the fingerprint, holding the fingerprint is not enough. Then if
It is necessary to that there should be some blood.
yes, yes,
Die person.
yes,
That should be
yes,
blood should come out.
yes.
Is it necessary?
There should be something apart from the fingerprint. Because merely holding the X does not justify that he had killed Ruby with that particular